According to Jayakumar, tendering process involves the contractor whom are interested in bidding for the tendered works. Contractors were invited to offer in which they have to prepare and submit the estimated price, thus will be the tendered price. There are 4 focal points that can be considered as the elements of an invitation to tenderers, which are notice to tenderers, pre-tender meeting, fees and deposit, and lastly, tender period. A notice to tenderers should be in a writing form, either in the form of an advertisement or a letter. The advertisement usually would be placed in the newspapers, websites, and other suitable media platforms. It is usually used for open tenders. For selective tenders and direct negotiated tenders, the invitation to tender would be in the form of a letter and be sent to the selected tenderers. The notice to tenderers sets out the matters in regards of time and place for the collection and submission of the tender documents, form of tender, tender period, closing date of tender, tender validity period, fees and deposits, and other requirements needed for the execution of the works. According to Hohe, it is very useful to hold a pre-tender meeting so that any clarification about the projects can be made and answered clearly. It is a common practice to hold a pre-tender meeting for the purpose of general orientation, introducing tenderers to the site, answer questions, and to explain and identify the important features of the project. The fees are determined by the client or the consultant. It aims to partially recover the cost of production for the tender documents and expenses involved during the tendering process. The deposit can be requested by the client towards the tenderers and it is refundable. The deposit acts as a guarantee for the tenderers to make sure that the documents returned will be in a good condition. And lastly, the tendering period. The tendering period is the period for the tenderers to price their tender documents starting from the issuance of the tender up until the pre-described tendering period, depending on which procurement method being used. There is little time given for the tenderers to prepare their tender estimate. The tenderers will make costly errors and will be deceived against money term values. It will take ample time for the tenderers to review records, visit and examine the site, decide on their materials and specification, arrange their financial details, and work on the sequences, procedures, and the techniques of their construction. The following flowchart is an example of how the process of the invitation to tenderers based on the following procurement methods.
As cited by Sambasivan and Sun in 2007, most construction projects experience completion delays, and the Malaysian construction industry is not an exception. The aim for the application of an extension of time is to reduce as well as to minimize the possibility of the contractors being charged with LAD if they exceed the completion period. Based on the announcement made by our Prime Minister regarding the Movement Control Order on 18th March 2020, all works have to be stopped unless those that fell under the essential services, unfortunately, not for construction and maintenance works. On 15th April 2020, the Senior Minister of Infrastructure has announced that finally the construction works can proceed while adhering to the SOPs, such as swab tests for the foreign workers, social distancing at site, as well as limiting the number of workers on site. In form of contract of PWD 203A, the list of force majeure incidents did not specifically mention about epidemic and pandemics. However, it did include that COVID-19 pandemic would affect the ability of the contractor to secure goods, materials and or services essential to the proper carrying out of works, which will entitle the contractor for an extension of time. In 1 2018, force majeure in Article 7 is any circumstances beyond the control of a contractor such as natural disaster, pandemic, epidemic and governmental actions. Thus, MCO is a governmental action that will lead to the application of an extension of time by the contractors. It is of the utmost importance that both contracts to comply and to fully follow the condition precedent in order to apply for an extension of time. Major difference is that PAM refers to the list of force majeure, but PWD 203A refers to the supply chain interruption where the contractor's abilities have been taken away to carry out the works properly. Based on EOT notice clause number 3 by Pekeliling Pembendaharaan Malaysia, eligibility to claim for an extension of time is automatically granted for government contracts. For both contracts, notice of EOT shall be given to the architect or to the superintending officer respectively within the specified period. When the Prime Minister has announced that we would shift from MCO to CMCO on the 4th May, the contractor can no longer claim for an extension of time. They could only claim from 18th March 2020 up until 3rd May 2020, which is equivalent to 47 days. However, in EOT Notice Clause 2.3 released by Pekeliling Pembendaharaan Malaysia, the period of time must consider the mobilization, demobilization as well as site readiness. For example, in Johor Public Works Department, they have granted their contractors an extension of time of 56 days instead of 47 days. Thus, there will be no LAD charges from day 1 until day 56.
Control order was being implemented to curb the spread of COVID-19 in Malaysia. Categorized as a force majeure event, it has caused many industries to suffer, and construction industry faced no exception. Loss and expense due to the event has to be bare and questioned, and who is responsible on the matter arise. Both PWD 203A and PAM 2018 mentioned that no claim under loss and expense can be made due to the force majeure events. No force majeure events are being included under the Clause 18.1 to allow for claim under loss and expense for FIDIC 2017. AIAC 2019, on the other hand, clearly mentioned that any claim related to force majeure events are only limited to claim for EOT. In spite of the clause previously mentioned regarding on this issue, contractor is still entitled for few possible heads of claims that is not consequences of force majeure events but related to the current unfortunate situations. The first one is loss of productivity related to any work suspended due to instruction issued by the SO or architect. The non-productive resources caused by the suspension of works are only allowed to be claimed if notice has been issued. Expenses which relate to the loss of productivity, to name few, are demobilization and remobilization costs, site staff salaries, accommodations, utilities and rentals for plants and equipment. The second possible head of claims is the increased cost of resources in a situation where the client refused to grant EOT. In order to catch up with the work program, additional resources need to be utilized to ensure speedy work completion. Any allowable claim under the contract must comply with the standard operating procedure that is stated in the contract to be approved. Condition that must precede the claim is the occurrence of matter as being mentioned in the construction contracts. For all the forms of contract aforementioned, notice of claims must be issued together with the necessary supporting documents must be submitted within period agreed to ensure approval and the amount of claim to be ascertained. Win-win situation must be proposed to both contractual parties to ensure successful project delivery. Recommendation to improve the situation includes the full utilization of work program, as the usage is crucial to analyze and evaluate the claims that the contractor might be entitled to under loss and expense claim. A more comprehensive financial communication system shall be established to ensure only relevant claims of loss and expense being granted to the contractor. In conclusion, the analysis of force majeure clauses in 4 different forms of contracts has identified differences and similarities of claim entitlement under loss and expense for different forms of contract. It also can be inferred that the event of force majeure as a basis for justification of claims for loss and expense is irrelevant, owing to the fact that the force majeure event is beyond the control of any parties. The extent of force majeure event is only limited to claims for EOT, and any refusal by the client to grant EOT to the main contractor will result in possible claims that can be made under loss and expense.